I'm Stelios Charitopoulos, and I'm a Senior Associate in the Competition Law team at Hogan Lovells. Today, I will share with you some insights into resale price maintenance, which is most commonly referred to as RPM. This is a topic that relates to common, everyday business arrangements and has long been on the radar of competition authorities, so I will share some pointers to help you stay on the right track. RPM is when a supplier sells products to a distributor or a retailer for resale and then seeks to restrict the ability of the reseller to determine their own price. In its most basic form, the supplier fixes a specific or a minimum resale price. However, RPM can also take less obvious forms. For example, fixing the margin of the reseller, fixing the maximum level of a discount that can be granted from a specific price level, making rebates or promotional funding subject to sticking to a specific price, prohibiting the advertising of prices below a certain level, or even linking resale prices to the prices of the reseller's competitors. Broadly speaking, it is true that vertical agreements between suppliers and distributors do not generally give rise to competition law concerns. Well, simply put, if powerful manufacturers attempt to control resale prices, it means that customers can be denied the opportunity to shop around, compare prices, and then find the best deal. Ultimately, competition authorities care about RPM because it harms the end consumer by exposing them to higher prices. With this in mind, it is not surprising that competition authorities consider RPM to be one of the most serious forms of anti-competitive behavior. And even though this is not a new frontier for competition law, they're always on the lookout for these arrangements. They have conducted several high-profile investigations in recent years, and that has been in product markets as diverse as fashion, musical instruments, bathrooms, and light fittings. However, all of this does not mean that businesses cannot exercise any control over their brands. Whilst fixing a specific or a minimum resale price for a product would amount to RPM, recommended or maximum prices in and of themselves, in most cases, will comply with competition law. So to stay on the right side of the law, remember, whilst recommended retail prices are generally fine, ensure that any agreements between resellers do not fix or control the price at which the products can be resold. Don't forget to pay attention to the more subtle forms of RPM, which may not be immediately obvious in agreements with resellers. Remember that things like specifying conditions on discounts and promotions may very well amount to prohibited RPM. And finally, if you're unsure, seek legal advice. Thanks for watching, and join us next time as we continue to navigate key trends and important topics that are shaping competition law today.